Hello, and thank you everybody for attending today's What Are My Child's Rights webinar. I'd like to introduce Tom, who's presenting from the Council of Disabled Children, and he'll be presenting for us today. Tom will be discussing the SEND Code of Practice, the responsibilities of the local authority to ensure a child or young person has access to the right education, and what support SENDIASS can provide. After the presentation, Tom will also be answering some of the questions that have been pre-submitted, and please feel free to raise any questions in the question facility while the presentation's going, and hopefully we'll be able to answer them at the end, or I'll forward them on to Tom and he'll be able to answer them. Lovely, that's enough for me. Thank you, and thanks Tom, I'll hand over to you now.
Cool, thank you. First of all, I'm going to start by trying to share my screen. I think I might need permission to share my screen. If someone's able to give me that. Ooh, lovely, thank you. Cool. So as Don mentioned, I'm Tom. I work for the Council for Disabled Children, specifically the Information Advice and Support Service Network, as we work with SENDIASS services up and down the country. As I mentioned to my Pocklington colleagues, I'm currently visiting London over from where I live in Chepstow for a few meetings. Now things are beginning to open up again, and so I'm relying quite heavily on Premier Inn Wi-Fi, which may or may not go great. So I have got a presentation today around children and young people's rights, especially with regards to sort of education and the responsibilities of the local authority. I have presented once before for Thomas Pocklington, and I know that a few people attending today attended that one as well. So I'm covering some of the same bits, but I've tried to sort of branch out and focus a little bit more on the law. The first part is quite law heavy, but I just wanted to say, don't worry too much about the sort of the heavier law stuff. I think it's just really important for everybody to know that it's there to protect you, that it's there to ensure that children and young people have the education and the support and services that they are legally entitled to. But as I'll get on to later, the role of SENDIASS, the role of sort of the services that I work with and other organisations who are sort of statutory services funded by local authorities, funded by central government, the role of them is to make sure that you are supported to sort of through any journey that you might need to take regarding the law to be able to get the support and services that you need. And there are other organisations out there who are fantastic as well, who are also either funded or grant funded to make sure that families are empowered to sort of understand all the rights and responsibilities out there. So although it's a little bit law heavy, just to say don't worry too much, and it's just good to know that it is there. And it's so quickly, the Council for Disabled Children, we're an umbrella organisation for the disabled children sector, and so we bring together practitioners and policymakers. So we are quite a good middle sort of ground, and so we work sort of hearing stories from the front line. We work directly with services on the front line, and we also work with policymakers, in particular with the Department for Education, in order to sort of make sure that the Department for Education understands what's happening on the front line and is able to sort of fund and support services as needed. And we're part of the National Children's Bureau, which is a larger umbrella organisation that works collaboratively across all children's services. And so to start with, fundamentally, and it's worth sort of remembering this, especially with regards to making sure that children and young people have the right to an education. It is a right. It's in Article 28 and 29 of the Convention of the Rights of the Child. So all children and young people have a right to an education. It's seen as a human right. So it's a good starting point. So when we're looking at sort of the legal processes and the legislation around children and young people's rights and the responsibilities of the support and services out there, all of it stems from this, that you have a fundamental right to an education, and that fundamental right needs to be met. And if you're unable to meet that sort of fundamental right through mainstream support and services, then you have a right to have additional support and services to make sure that you can have that right met. So it's a fundamental human right, and that's sort of where everything then stems from. And so sort of mentioned, all children and young people have this right to education, and children and young people with special educational needs then therefore have a right to receive special educational provision in order to have the opportunity to access an education and to meet their potential within an education. So it's still not just a basic education, It is, you know, education is there to support children and young people to have the opportunity to meet their potential. If you need special educational provision in order to be able to access and engage with your education, in order to be able to meet your potential, then you should have special educational provision in order to do so. And again, that's sort of one of the starting building blocks of all the sort of the acts and the code of practice and the legislation around it all. And it all is quite simple, that everybody should have an education, and if you need specialist support and services in order to be able to engage with their education, then that's what you should have in order to be able to have your human right met of being able to access an education. So the SEND reforms, which is it sort of goes into the detail of how, so I'm just going to minimize myself so I can see the whole screen. The legislation sort of regarding the legal systems and processes to ensure all of that happens, and where you get into sort of the more complexity and the detail of it all, is contained in Part 3 of the Children and Families Act. And so, as I'll sort of mention in a minute, the Code of Practice, which is one of the things I sort of asked to speak about today, is basically a guide to Part 3 of the Children and Families Act, and sort of goes into even more detail. So you have that sort of fundamental right at the start, and then you have the sort of law that puts all of the processes and services and support and policies into place to make sure that that fundamental right can be met. And with the Children and Families Act, the only other act that I'm going to mention today, and again, as I said at the start, it is quite law heavy, but we'll sort of move on through that and to the end, where we can sort of talk a little bit about the support and services you can get to navigate all of this, is the 1989 Children's Act, which puts the responsibility on local authorities to make sure that children and young people have access to services and support if they should need it. The Equalities Act, which sort of covers everything, which basically says that you shouldn't be discriminated against because of any protected characteristics, including disability, and the Code of Practice, which I've sort of mentioned, and I'm going to mention some more as we go through. And so the SEND Code of Practice explains in more detail the duties of local authorities, health bodies, schools and colleges to provide for those with special educational needs in order that they meet sort of their duties under Part 3 of the Children and Families Act. So the Act details legal requirements that must be followed without exception, and contains statutory guidance that must be followed by law unless there's a good reason not to. And you'll find a lot of language throughout all of these bits and pieces, such as good reason not to, that can seem a little bit vague and not particularly helpful and can be interpreted as such. But when you actually look into it, and especially sort of with regards to case law, and again, don't worry too much about case law, there's lots of services and support that will be able to point you in the right direction with regards to case law. But when we're talking good reason, it has to be a very good reason, where a child or young person might come to harm if that guidance was followed in that particular instance, or there's a real reason for that hasn't been explored before, that has come up, where that statutory guidance can't be followed for a particular reason. I think the only time I've ever seen it in my career is regards to people who have particular sort of health needs, who may need to be involved for a long time, which means they can't access school in the way that others may be able to, but it still doesn't change their right to an education. It just, the statutory guidance can't always then fit that particular situation. So the good reason has to be a very, very good reason, and keeping that child or young person at the centre of everything, as always. So it's also worth considering the Children and Families Act and the Code of Practice, along with the Equalities Act, because the Equalities Act encompasses everything, and it's sort of one of the overriding acts that's always sort of worth keeping in mind. Because it is against the law to discriminate against anyone because of the protected characteristics, and that includes disability. Within that includes the duty of all local authorities to make reasonable adjustments, especially around inclusion. So as we'll get into later, some of the times the Children and Families Act doesn't always fit every school, for example, but it fits every sort of mainstream school, or maintained school. But not necessarily every independent school. But that doesn't change the fact that independent schools still need to be mindful of the Equalities Act, so can't discriminate against. So they all sort of work and overlap, and are worth sort of looking at in conjunction with each other. And disability in the Equalities Act, just to sort of raise again, is a child or young person has a disability if they meet the definition within the Equalities Act, which is if you have a physical or mental impairment that has a substantial and long-term negative effect on your ability to do normal daily activities. And it's quite a good definition of disability. We feel, and sort of certainly was better than the one that predated that from the Children's Act. And it is quite intentionally sort of not quite vague, but it is quite all-encompassing, which makes assessment processes much easier to access. So it's worth sort of keeping in mind that the legal test within the Equalities Act for disability has got quite a lot of flex. Responsibilities of the local authority within these acts and within these sort of processes and code of practices is that they have a legal duty to identify and assess the special educational needs of children and young people for whom they're responsible, and they're responsible for children and young people who live within their area, and they need to be sort of identifying and assessing as soon as they become aware that the child or young person has or may have SEN. And that's taken from IPSI, who are one of the partner organisations who we work with quite closely, and who are a group who are sort of legally trained, sort of made up of many sort of lawyers and barristers who sort of moved into the charity world. And again, so that's sort of worth mentioning. So, because a lot of the law and the the code of practice and the Children and Families Act and all these sorts of bits and pieces, they are complex and complicated and huge, and the code of practice is nearly 300 pages long. But actually, at the heart of it all, it's quite simple, that children and young people have a right to education and support and services in order that they are able to meet their potential within education, meet their potential within society, access the community, actually have their human rights sort of protected. And it is the authorities' duty to find out who those children and young people are and assess their special educational needs in order to provide those support and services. So at the heart of it, it is all quite simple, and everything else around it is the sort of the detail you need to be able to challenge and to be able to sort of really sort of push for your rights and responsibilities. And like I said at the start, there's lots of services out there who I'll get into in more detail in a bit, who are there to be able to support you and help navigate through all of this. So again, it's worth just remembering the definition of special educational needs, just to sort of consider when we're looking at who has access to these support and services and who has how to get the assessment processes going in order to be able to access those support and services. So again, the legal test is quite low, the bar is quite low. A child or young person has special educational needs if they have a learning difficulty or disability, which calls for special educational provision to be made for him or her in order that they are able to access education, have their opportunity to reach their potential. So it's any need that means that while in school or college or whatever educational establishment that you're in, you need something put in place, a special educational provision, in order to be able to access that education and reach your potential. So that could be anything from sort of having certain support within the school, having information presented in a way that's accessible, having interpreters, having whatever that might need, whatever you might need in order to be able to access education, have the opportunity to reach your potential. And again, that's worth considering along with the Children's Act, which I mentioned at the start. And again, I'm sorry for all of these acts, but they all are important and sort of all do cross over. For the Children's Act in 1989 is where a lot of sort of the legislation around support and services comes from. And it's worth sort of remembering that it should be the general duty of every local authority to safeguard and promote the welfare of children within the area who are in need. And as far as is consistent with that duty, to promote the upbringing of such children by their families by providing a range and level of services appropriate to those children's need. So this is the first, section 17 brings in this idea of children in need. Children and young people identified as having a disability are automatically classed as children in need, and therefore they should have the range and level of services appropriate to the needs in order to be able to sort of meet their potential. And that's sort of mostly with regards, and that set into support and services to be able to access the community, social care assessments, those sorts of bits and pieces. But again, it's worth noting that throughout all of this, the legal bar in order to be able to be assessed in order to access these services are quite low, which is a good thing because it means that you can use these sort of tests to access assessments if you feel that you do need, or your child or young person does need, additional support and services to have their human rights met, whether that is within education or within society and the community. So section 17 of SEND, so just to bear that in mind again, I'm getting a message every now and then saying my internet connection is unstable, which is what I was slightly concerned about. So if I am cutting out, I apologise. And if I have sort of left you and I'm talking to myself, if someone could let me know, that'd be great. Because all I can see is my screen. But for the purpose of this part, a child should be taken on as to be in need, so to be able to sort of meet that sort of section 17 criteria. If he's unlikely or she is unlikely to achieve or maintain, have the opportunity of achieving or maintaining a reasonable standard of health or development without the provision of services. Again, with the health or development, it's likely to be significantly impaired or further impaired without the provision of such services, or is disabled, has a disability under the definition of disability, which we looked at a second ago within the Equalities Act, which is the substantial and long-term impact on your ability to do day-to-day activities. So again, all of these bars quite low, which is a good thing. The law is there to protect and make sure that children and young people have the right to access education, access their community, have their human rights met across the spectrum, including sort of where other children and young people would be able to access support services and the community and education, and without the provision of additional support and services. So essentially what it all boils down to, and I did want to touch on the law because I think it is important to know that it's there and it's there to support you, and it is there to support the children and young people who need support and services in order to be able to reach their potential. But when you boil it down, children and young people have a human right to support and services in order to be able to have their rights met, and LAs must identify and assess those who have or may have special educational needs and disabilities, and provide appropriate support and services across education, health and social care to meet the needs and rights of the children and young people in their area. And they must make sure that you understand your rights and their responsibilities in order that you are absolutely confident that you are getting all the support and services that you're entitled to, or that your child or young person is entitled to. So at the core of it, it is quite simple, which is a positive thing. And I think we could all do with a little bit more simplicity in these areas. But essentially, that if your child or young person isn't accessing an education because of their needs aren't being met within that sort of education establishment, then the LA has, it must identify and assess to find out more about those needs and then provide the right support and services, whether through SEN support or through an education, health or care plan, if your child or young person, or if you are unable to sort of have your needs met through SEND support, in order that you are able to access and engage with and have the opportunity to do as well as you possibly can within education and outside of education, also under section 17. So moving swiftly on throughout the law, so that I wanted to touch on the law partly because that was one of the topics that was raised, and also sort of as I was asked to, but I think I sort of run through that a little bit to sort of move on to more maybe why some of the people here may be wanting to learn more about all of this, is around what you can do if you feel that you're not getting, or your child or young person's not getting support and services, or the assessment in order to get the support and services as they should, and what you need to, or how you can challenge and dispute that sort of assessment process, or the support and services directly to take. So your first step is always to raise a complaint using and following your local authority's complaints procedure, and to take anything further to be able to challenge down the line, whether at tribunal, with a judge, through judicial review, or through the local government ombudsman, that we'll touch on in a minute. You need to be able to first show that you have followed the correct complaints procedure. It's always worth doing things by the book to begin with, because it just means later on, if you are trying to challenge and trying to sort of take things further, you can show that you've done it by the book, because that's the first thing they'll say is, oh, you know, we shouldn't be here, we should have raised it as our complaints procedure shows. So if you feel that you are not getting the support or services, or your child in support or services or assessment processes that you should be, follow your LA's complaints procedure. They legally have to have that on their local offer. I hope everyone knows about their local offer website. It is a statutory responsibility of every local authority to have a local offer website, and on that local offer website will have information about every element of support and services available to children and young people with SEND and their families, all in one place. The assessment processes, the numbers you need to call, the local services within the area, short breaks, anything like that all has to be on the local offer, including the complaints procedure. So that's your first port of call if you want to challenge your current situation, is to raise that through your complaints procedure within your local authority. And if you do so and you're not satisfied with the answer, and you feel you're in a position to take things further, possibly with support, you have options to raise things further. So if you're challenged, if you feel that the local authority has not carried out its duty with regards to identification and assessment with regards to any EHC needs assessment or to issue an EHC plan, those go through the SEND tribunal. So you'd be able to raise an appeal with the SEND tribunal to say that you feel your child, young person, or yourself hasn't had, or it's one of the sort of more common complaints is that you've asked for an education healthcare needs assessment because you feel that your child, or young person, or yourself is not able to fully engage and access with education through SEN support, which is your first port of call. And if the local authority says, no, we think you're doing perfectly fine in school, or we think SEN support can meet your needs, then they may say, we refuse to do an EHC needs assessment. And that's something, if you dispute that, that's something you can raise through the complaints procedure, and then appeal through the SEND tribunal. Equally, if after an EHC needs assessment they refuse to issue a plan, then you can take that to the SEND tribunal if you feel you're in a position to challenge. There's lots of organisations out there who can give you the information. So this is where we sort of get more into the role of SENDIASS and organisations like IPSI. They're there to make sure that you are empowered with the information about your rights, about their responsibilities, about the processes, so that you can make an informed decision about whether you feel that going through the process of challenging a tribunal is worth it, if there is a chance that you would be successful by giving them the information, and they are impartial, and so they are not part of the local authority. They're funded by, purely because the local authority has a statutory responsibility to make sure it happens. They have to be impartial under the law, and they have to be impartial. We make sure that, you know, we're supporting them in order to be so. So you can trust that the information that they're giving you, we you know, in all cases, well, no, obviously you can't say all cases, but you know, they have to be impartial. That's their role, and that's what the law says they have to be. So they are there, and IPSI are there to give you the information, the letters, the wording, the support, even direct support in certain situations about paperwork we can get more onto later, in order that you're able to challenge those decisions should you need to. If you feel the LA has not carried out its duty with regards to the provision of support and services, you can raise a complaint through the local government ombudsman. The local government ombudsman is where families and children and young people can raise complaints that aren't heard at tribunal. So that's anything that, you know, not regarding the EHC needs assessment or the EHCP, issuing an EHCP, and includes if the local authority has failed to appropriately address a child SEND, including implementing the support detailed in the EHCP or carry out an annual review. So if you know, a school hasn't, if you haven't had an annual review, but you feel you need one to make sure that the child or young person is getting the right support and services, or if there's something in an education, health and care plan, for instance, you know, if it says clearly in your EHCP that you're entitled to 6 hours speech and language therapy a week, and you know that your child or young person isn't getting that, then you take that to the local government ombudsman. They have the power to issue compensation, amongst other things. And actually, if it's worth sort of having a look at some of the things that have been raised to them, which is quite interesting. At the moment, it's got quite a terrifying success rate. with 9 out of 10 complaints finding in favour of the family, which is worrying, because, you know, frankly, there shouldn't be so many times where children and young people and families aren't getting support and services they should be entitled to. You'd hope the rate was more like 50-50, where there's sort of occasional things being challenged, rather than 90%, where it's clear that in the most part, when these complaints are being raised, that the right support and services isn't being given. But that's what they're there to do. So if you're not getting the support and services that you should be getting, you can raise it with the LGO, and like I say, they do have powers to force the LA to compensate in certain situations if a child or young person has suffered as a result of not getting the support and services that they should be having. And I put the website there in case you do need it. And so this is sort of going full circle to basically, it's a lot of information, but you don't need to know every single bit of it. So the whole point of sort of SENDIASS and that side of the SEND reforms, which all came into law at the same time, so the SENDIASSes and Contact, who provide the national information, advice and support sort of phone line, are there to make sure that it's not, the power isn't imbalanced towards children, young people and families, because the professionals all know the law and have had training in the law and have worked within the law for many years, and families may not necessarily have sort of had that sort of experience before, and they may work in different fields. That, you know, the time pressure of having to try and like research all of this stuff, as well as work a full-time job and be parents and everything else that you have to do, it's next to impossible. So the idea is to try and address that imbalance of power, to improve relationships between services and families and children and young people. Was this idea that there should be services and support that are impartial and confidential, that can give you this information and sort of put into, support you and put into sort of better context what you are entitled to, what the responsibilities of the services around you are, without you needing to go find the page 133 of the Code of Practice in order to put that in front of your local authority. That's what they're there to do. They're there to find that page for you. They're there, they have legal training. We provide that training within the Information Advice Support Service Network. We have we commission IPSI to provide 3 levels of legal training. We also put on training on exclusions, on repairing for adulthood, on social care, on health, on all these sorts of bits and pieces, in order that they know it all, so you don't have to know it all. So when you do approach them and say, this is the situation, I don't feel that my child or young person is getting the support they need at school, what can we do? They can go through it all with you. They can tell you what they should be entitled to. They can tell you how to challenge. They can give you model letters. They can, you know, everything that you need. That's what they're there to do. Because, as I said at the end, no one's superhuman. You know, I think families are under enough pressure as it is. You can't be expected to, you know, you're already expert parents. You're already experts in whatever career. If you've chosen a career that you're doing, you can't also be experts in the law. So that's why we fund others to be experts in the law, to make sure that children and young people have the impartial information, advice and support that they need in order to be able to get the support and services that they are entitled to. So there are 152 services, one in every local authority. They must provide information, advice and support through a variety of different ways. They are free, so they're funded by your local authority, but they are not part of the local authority they're arm's length from. They're impartial and confidential, and they also receive additional funding on top of that. And they have the support around them from independent organisations such as my own, in order to sort of make sure that they are able to maintain that impartiality and that confidentiality. As I say, because it is a statutory responsibility of every local authority to make sure that the provision of information, advice and support is available, and that it has to be impartial and confidential, which is, again, it's the law. And if you feel that that isn't working, you've got the same right as redress as before, in terms of sort of challenging SENDIASS through your local authority complaints procedure, through us if you need to, and through all the same avenues as before. And you do have Contact and IPSI and us who can support you through that if you feel your SENDIASS is unable to. what they can do, they can provide support resources and information to help children, young people and families understand what's going on in their local area. They can provide information about school, early years, social care and health processes and procedures and how to access support, provide information and advice about funding, dispute and challenge and how to go through those processes. And in some circumstances, if you need it, they can also support you directly regarding preparing for meetings, paperwork and participation in meetings, should the situation and capacity allow that. They can also be seen as advocates, but we're very careful about that because advocacy can mean a lot of different things for a lot of different people. But in this instance, they can advocate for you by supporting you to help you express your view in which you understand and exercise your rights. But they don't fulfill the role of statutory advocates, nor do they provide legal advocacy as would be provided by a lawyer. So they can support you, but they're not legally representing you, again, because they have to be impartial. And more information about advocacy can be found through the Mine website there. But I've also put a few more bits and pieces because I think it is a bit of a contentious bit, and it's worth knowing that they, acting as an advocate, the SENDIASS worker can listen to your views and concerns, help you explore your options and your rights without pressuring you, provide information to help you make an informed decision, help you contact relevant people or contact them on your behalf, and accompany you and support you in meetings or appointments as appropriate. But they won't give you their personal opinion because they have to be impartial. They can't solve problems and make decisions because they have to be impartial, and they can't make judgments about you. And challenge. So as I mentioned before, that there are these SENDIASSs who are there to be able to support you to address that imbalance of power. There's also lots of other organisations that can support you too. I'm putting a link there to a comprehensive list. At ISSN, we chair a meeting called SENDIOG, which is the Special Educational Needs and Disability Information Advice Group. And basically, we get together with the heads of charities and organisations such as Contact, IPSI, the National Autistic Society, the Down Syndrome Association, all of these different groups who come together and sort of look at information, advice and support as a whole. And the advice that's going out there. So there's lots of different organisations out there. The whole SENDIOG list is there. And there are lots of very good sort of organisations that will be able to support you with the information, advice and support. Such especially organisations like Contact, who run the information advice line, who is a good sort of second sort of place to go, sort of other option, second option. If you are uncomfortable contacting your SENDIASS for whatever reason, or if you had a question that you didn't feel needed to be raised through your SENDIASS, and that's again why they're there, to give you the extra layer of support and service. Just to bear in mind, because this has become something that's become more of an issue recently, because the recent rise in cases of the SEND Tribunal has been large and quick, and much quicker than it should have been, because of sort of the problems with rolling out needs assessment and plans. There has been a rise in individuals setting themselves as advocates. You're obviously, if you did want support and services, you are very entitled to work with an independent advocate supporting you through the process, but they more often than not will charge, and it is worth having a bit of a dig into sort of them and their sort of their motivations and any sort of references. We've developed some guidance because I'm sure some of them are sort of very positive, but also it's worth remembering that you have a legal right to free, impartial information, advice and support, and that the services out there who sort of the SENDIASS services, the IPSI services, Contact services are all well funded in order to make sure that we have the training and the resources and the tools in order to be able to make sure that we are able to provide all those services, to provide that free, impartial, quality information, advice and support. If you do feel you would rather have support from an independent advocate, it's completely up to you, but it is worth having a look through the guidance that we've developed and just making sure that you get the right one, and making sure that you're aware of how much they charge and why they charge, and all of those sorts of bits and pieces. So there's a guide here, and obviously we'll share these slides at the end so you can have all of those bits and pieces. I just wanted to touch quickly on independent schools and college, because there was a question specifically about that, and I had to go had a bit of a chat with my colleagues over at IPSI to find out a little bit more, because it's not something that I've had a lot of dealings with. But it's worth mentioning that Part 3 of the Children and Families Act doesn't necessarily apply to wholly independent schools or early years settings, which obviously the Children and Families Act and the Code of Practice come hand in hand. So that would mean the Code of Practice also doesn't necessarily apply. It isn't as simple as that, and I have made some notes that I want to quickly bring up, and I wonder if I can do that while talking, whether you can. It's basically, if your child has an education, health and care plan, it is the local authority's duty to ensure that what the provision set out in that plan is made. So but under section 42 of the Children and Families Act, the LA do not need to do so if you have made suitable alternative arrangements. If the independent school is named in section I of your child's EHC plan and there is no other suitable school which your child could attend, it is likely that the local authority remains responsible for your child's special educational provision and should be paying for the special educational provision. But if the LA suggested that a different school should be named and you chose to send your child to an independent school and pay for it, then it is likely to count as making suitable alternative arrangements under section 42, and so the LA would not then have further duties to fund that. So I just wanted to mention that because it wasn't something I know doesn't happen. It happens quite rarely, so I just wanted to make sure that I got that right. But essentially it means it depends on how that school was chosen, and if the family have made a decision, if the local authority have identified a suitable alternative school that isn't independent, and the family have decided that they would rather pay for an independent school, then that counts as making suitable alternative arrangements, and then the EEC plan would then no longer entitle the local authority to pay those fees. So that's hopefully helps a little bit with that question. Incredibly complicated. Worth noting that the Equalities Act always applies. So a child or young person cannot be discriminated against due to their disability still applies. So the school would have to make reasonable adjustments still legally to make sure that the child or young person is able to access their education. And I think because of the complexity of it and because of the sort of the different elements to it, if you're in that situation, I think the best thing to do would be to make an appointment either with your SENDIASS, make a phone appointment with APC, or contact National Helpline, talk through the whole situation, talk through where the school is named, whether the school was named in section I, go through the sort of the, how it came about that child or young person wanted to go to an independent school, whether the local authority was able to name a suitable other alternative, and they'll be able to sort of get to the bottom of whether or not the local authority is still in that situation legally responsible for paying the fees. So it's worth noting that it's have a chat with some trained professionals, and they should be able to walk you through some of that situation. That's just sort of a bit of a page on SENDIASS, which gives you a bit more information about some of the alternative organisations out there that can support. There are lots on there, so it's worth sort of clicking through. That's just a very quick snapshot. And just a page on how to contact your local service. If you did want to find out where your local service was, you can either find that on your local website, and you should already know through social media leaflets and referrals from anyone within your local authority, or would hope so. There's also a tool on our website, the Council for Disabled Children's website, where you can click through the map and find where your local service is. And if you want more information, and this is a very, very quick sort of run through, I basically just wanted to make sure that I covered the main points around what law is out there, what law is worth being aware of, but then sort of have a bit of a focus on where you can get support to navigate the law and the everything, sort of the complexities of it all. But if you want more information about us, and including resources and information, you can find that on our website. And there's lots of videos there. We have social media, we have a monthly newsletter, and we always have sort of information about what changes, support and services that are out there through all of those bits and pieces as well. And so you can always sort of find out more through those avenues. I find it really hard when I'm presenting these days because I have no way of seeing the time as I'm going. So I've got no idea what the time is and how I'm doing for time, and whether I'm at the end of my time or how much time I've got for question and answers. But I am
You're on 5 to 7, Tom.
That's right, isn't it?
Yeah, so you've got your time for questions, and there has been a few more added to the questions and answers, as well as the ones that have been pre-submitted.
Cool. Yeah, okay, cool. How did you want to do that? Did you want me to go through the ones that have been
pre-submitted? Yeah, please, if you're happy to do that like last time.
Yeah, okay. So the questions that were pre-submitted, the first one was, if an independent nursery refuses to take on your baby because she is blind, what are your options? And as again, as I mentioned sort of towards the end there about independent early year settings and independent schools and colleges, the Equalities Act still applies. So they can't refuse to take on your baby because she is blind, and they have to make reasonable adjustments in order to be able to ensure that your baby can attend. It's worth discussing that in more detail with SENDIASS. I mean, it's going to be very rare that there are reasonable adjustments that can't be made. It would be very surprising. It would have to come down to the welfare of your baby, but adjustments can be made in most cases. So, I mean, without getting too into it, I'd be very surprised if you couldn't challenge that. But it's worth talking to SENDIASS or talking to contacts and just sort of going through a little bit more about the detail and the actual reason they've given for refusal. Because if they've literally just come back and said, well, she can't attend because she's blind, then that's direct discrimination, and that can be challenged at various different levels to change. The second question was, does a baby who is blind qualify for an EHCP if that is her only need? Again, it's if her vision impairment, if she's blind and needs educational provision above what can be offered by SEN support within the school, then she can absolutely qualify for an EHCP. It doesn't matter whether there's one need, two needs, multiple needs, or what those needs are. What matters is if that baby, that child, that young person, if they're not able to meet their educational, have the opportunity to meet their educational potential within their educational institution through SEN support, which is the money that all schools, colleges get to be able to include children and young people with SEN. If they need support above and beyond that, then they can qualify for an education, health and care plan, absolutely. If the school says they don't have the funds to implement the EHCP, what can you do? I mean, that's it. An EHCP is a legal document. They have an obligation to provide the support and services within that. Not having the funds is not an excuse. They should have the funds. EHCP funding come with funding. It would be interesting to know where those funds have come from. You can complain. You can follow all the steps that I mentioned before, depending on how you wanted to do it, depending on how you felt and how whether you were satisfied with any resolutions as they went. And if you weren't getting support and services, essentially you can end up complaining to the local government ombudsman, and that will often come with compensation if needed, or at least come with an apology and services reinstated. But if they feel that child or young person that has had suffered as a result of not getting the services that they should have had through their EHCP, then you could well end up with compensation as well. So it's worth considering and worth looking into. So the question 4 again was around sort of attending education in the grammar school. I'm not going to get too into that one because I think it's worth a service sitting down and sort of going through the options, because it is complicated. I mean, there is always possibility to continue. You can't be discriminated against because of your disability. You can have support and services in place in order to meet your potential. If your son can have reasonable adjustments made in order that he can access that grammar school, then legally the grammar school has to provide just the Equalities Act. It still exists whether or not we sort of get into the detail of code of practices or anything else. Fundamentally you can't be discriminated against because of a disability, and if reasonable adjustments can be made, then they should be made. But it's worth sort of going into a little bit more detail with a service and with a person, and sort of explaining a little bit more about the situation, and they'll be able to give you sort of empower you or support you to do everything you need to make that decision. And the last one is, how do I challenge the LA Health Trust to be heard? And so, I mean, I've mentioned a few different ways you can legally challenge, and there are other softer ways that you can challenge as well. So you can legally challenge through the complaints procedure, through the ombudsman, through the tribunal, through all of these different processes. But you can also challenge at a local level and a soft level through your parent carer forum, and through sort of SENDIASS, through other local groups, by just reminding them of your rights and their responsibilities. I mean, legally, you have to be heard. You know, the child or young person's right to have a voice is a right. Again, what's a human right? It's Article 12 of the United Nations Convention. You know, you as a parent carer also have that right. If it's a parent carer who's asked this question, so you have to be heard. And if you're not being heard about something that you feel you should be entitled to, then you have your sort of routes of challenge and of redress that you can sort of take. And again, if it's a particular situation, and if you think it's about accessing support and services, there are those organisations out there who can empower you to sort of have the information and the support that you need to be able to challenge and to be heard. And they were the 5 pre-submitted questions. Are there ones in the Q&A? Yeah, there is. I don't know if can you see it, Tom, or do you need me to read it out? That's right. I've just opened it up. I've opened up the Q&A part, at least, not the chat bit. So there's a question about having fortnightly calls for social care, but there's little progress. Current support care package not fully available. I guess, I mean, if you're not getting the support and services you need through social care, we're also been supported by SENDIASS. I mean, it sounds like you're doing everything that you can in terms of sort of getting support from SENDIASS as well. I mean, the routes that we've sort of spoken about, that we've covered, are the ways that you really can challenge. I mean, but your SENDIASS worker will be able to sort of talk you through that. Again, the local government ombudsman, never say ombudsman. And the LGO is the sort of the formal route of challenge if you're not getting social care support or support that you should be entitled to. And they can, again, the local government ombudsman can direct services to apologise and to give you the support that you should have, and if needs be compensate as well. Yeah, and again, you know, you do think that it's quite a sort of, you know, an unlikely thing to have success through, but as mentioned, 9 out of 10 challenges to the ombudsman are currently being upheld, which is, like I said, crazy. And but so it's worth going that route if you really do feel like you need to. Okay, that's lovely. Thank you all for attending today. I hope you've all learnt as much as I have. Thank you, Tom. I mean, it's been a brilliant presentation, and for sharing your great amount of knowledge with us all. And I know you've had to whiz through it. We will be sharing the presentation, and there is all links on the presentation so you can find the information that you need. We're nearly at the time now to be finishing the session. So thank you for everybody for attending. Don't hesitate to contact myself or the Children, Young People and Families team. The information and the emails has been put on the facility. And all I can say now is thank you very much. Bye, and I hope you all have a nice evening and a great weekend. Take care and speak to you soon. Thank you very much, Donna. Take care. Bye.